Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, Stewart Banner gives an assessment of the office lease environment using a fairly standard contract. So, let's tear it down. Hey everybody, welcome back to the Contract Teardown Show from Law Insider. I'm Mike Whalen, Chief Community Officer at Law Insider. I'm here with my friend Stewart Banner. Stewart, how are you today, sir?
Doing very well, Mike. Thanks for having me on.
I appreciate you being here. We're talking about something that I think I may have actually signed myself before, which is not usually true with a lot of these contracts. This is a standard office lease by and between Arden Realty Limited Partnership and Aruba Networks. Stewart, what is this document? When are we going to see this kind of thing?
Well, typically when you're a tenant and you want to lease space in an office building, or if you're a retailer, maybe in a strip mall or regional shopping center, that kind of thing. Maybe if you are a manufacturer, you want to store goods in a warehouse. There are all kinds of leases. And of course, there's the residential lease, which we all have probably seen and signed, maybe to our chagrin. But for the most part, any lease, whether it is commercial or residential, typically the landlord has the upper hand. And they're the ones that usually draft the document, and if you're a tenant, you may think you don't have any negotiating room or can't change anything, but never hurts to ask. So when you go in, just if you are the tenant, just consider that it is negotiable, and you can ask for changes. And if the other party, the landlord, turns you down, that's maybe the best you can do. But always go on the assumption that you can get in some points. That maybe
and it depends on the context, right? Like we had a conversation, 2, maybe 3 years ago about a lease. And back then it was just post-COVID time or during COVID time, and the context was totally different. I encourage people, after Stewart and I have this conversation, for you to go back and watch that conversation. We'll have a link to it in the show notes. But times are a-changing, and I'm curious to see your perspective on what's going on with leases these days. Well, for now, let's start with some of the details in this document. I want to get you to critique some of the writing, some of the ideas in here, and also explain where appropriate. Let's start with Article 9, Repairs and Alterations, and it shows landlord's obligations. In general, I would say that this contract is relatively long, relatively detailed. There are sections on here in terms of what good condition means, that who owes what. What are you seeing in the landlord's responsibilities under repairs and alterations?
Yeah, it is fairly detailed, and typically in any kind of lease, be it commercial or residential, landlord is usually going to be responsible for the structure of the building, and sometimes within the premises itself. They'll be charged with a lot of the operating costs, of course. So the landlord will basically be responsible for anything outside the door of the office, if it's an office lease. And we'll want to make sure it's structurally sound, so on and so forth. If there are any capital improvements to be made, any repairs, that's usually the landlord's responsibility. The tenant is responsible for anything inside their respective space. And the main thing the tenant should be concerned with is not doing any harm, not damaging the space, leaving it in roughly the same condition when the lease is terminated. When they vacate the space is when they take the space. Sometimes they even may make improvements, and you have to be careful if you're a tenant and see what your rights would be as far as taking some of the improvements with you when you leave the space. If they're considered permanent fixtures, then ordinarily the landlord would have the right to retain those improvements and not have to compensate the tenant.
Well, are you seeing any red flags in the language in this particular lease that makes you think maybe they didn't draft this wisely?
Not really. It's pretty specific as far as what the obligations are for each of the parties. I do notice there's some pretty specific language about what the tenant has to do if they're to make repairs. They have to get basically the landlord's permission, especially if they're going to do something beyond just a cosmetic alteration. Usually a landlord will allow a tenant to make changes if they're just somewhat superficial, painting, that kind of thing. I would like to see probably some more language about what would be defined as, say, a refurbishing in the premises and what would be considered a remodeling. Usually if it's a remodeling, which would involve more work, that would be where the landlord would want the right to approve the contractors and things like that, and make sure the plans are acceptable.
Yeah.
If it's just refurbishing, touch-up painting, replacing flooring, that kind of thing, usually a landlord will just say that's fine, or they may put a dollar figure on it and say, well, anything that costs more than, say, $10,000, we have pre-approval rights, where if it's anything less, of course, you can do it without our permission.
Yeah.
I think here it's $50,000 is kind of the cutoff.
Yeah, so don't just go to HGTV and get a little hobby and start breaking down walls. Well, let's jump down to Article 12. It talks about the rights of the landlord. There's stuff that you would see pretty commonly in here about right of entry and their ability to do the maintenance work. What I'm seeing in this one that I want to call out that's interesting to me is there's a reference to communication equipment about 20 times in this particular section. What are you seeing in the landlord rights section, and why are they calling out this equipment in particular? When are you going to see that kind of specific protection?
It's usually going to be if it's, say a high-rise building, when the landlord may also own the building. They're very cautious about giving people access to the communications tower. That kind of thing. It's a big investment on their part, so they want to make sure that the tenant doesn't do anything to disrupt the equipment, to damage it. So they want to be very specific about what rights, if any, the tenant would have to make any alterations or changes, or if they might interfere with the equipment in some way. Maybe they have their own equipment that may cause some damage to the building's equipment. So I think that's the biggest concern here by the landlord. And of course, if the tenant does cause any damage, they're responsible for the repair costs.
Any other language in here that stands out to you in terms of landlord's rights? Does this seem overly one-sided in one direction or another?
Yeah, it is pretty landlord-friendly, as most of these provisions are, and as most leases are. And but at the same time, it does obviously give the tenant access to the communications equipment to share in whatever benefits that the equipment may provide, and it also gives the landlord the right to, of course, to do the repairs and maintenance. If the tenant wants to go on the roof for whatever reason, install their own equipment, of course, they have to receive the landlord's permission before they can do anything.
Got it. Let's jump down to assignment and subletting. I mean, obviously you see this in, normal people go in and get an apartment, the ability to sublease. I'm looking through this. It allows them to transfer that the lease to someone else, but obviously there's a bunch of landlord protections in here. My favorite one is that the landlord can deny consent if the proposed transferee is either a governmental agency or instrumentality thereof. We will not have the man in this building. What do you see in the assignment and subletting section?
Yeah, that's a good point. Government agencies tend to be a lot more demanding when it comes to lease negotiations. So I guess the assumption is that if a tenant wanted to transfer the lease to a government agency, the agency would demand extra concessions, maybe that another tenant may not get. They may want a longer-term lease, that kind of thing. They may demand a lower rent. So those are probably some reasons why the landlord would prefer a commercial tenant as opposed to a governmental agency. And usually the landlord wants approval rights. The typical language is the approval shall not, or consent shall not be unreasonably withheld, which means that the tenant has to meet some qualifications, or at least the assignee or the transferee has to meet some qualifications. You usually want to have the sublessee or the transferee to have at least the same net worth or the same financial wherewithal as the original tenant. And sometimes it's a subsidiary of the tenant, which is, more often than not will be approved, or an affiliate, or sometimes the original tenant may want to sign the lease if they're merging with another company, that kind of thing. So basically the landlord wants to make sure they're still going to get paid, that the tenant's not going to have any different use, or is going to basically have the same consistent program as the original tenant, and not do anything different. Sometimes there are other qualifications. It must be a similar net worth, that kind of thing. But the best way to prevent any of these potential problems, at least from the landlord's perspective, is to make sure the original tenant is still on the hook. So if the landlord does grant approval for an assignment, the tenant is still responsible for making sure rent is paid and so on and so forth. That way the landlord has double protection.
Got it. So don't let a government move in and have a rocket fuel factory in my building. All right, let's jump down to Article 29. This is surrender of premises and a removal of property. I, especially to call back to something you mentioned before, want to mention D, all fixtures, tenant improvements, alterations and or appurtenances attached to or built into the premises during the term, whether at the expense of the landlord or tenant or both, shall be and remain part of the premises and shall not be removed by tenant at the end of the term. What do you think about these rules in here about handing over the thing, and if you left anything in there or made it better, it's my thing now? What do you think?
Yeah, I mean, that's a big leverage that the landlord has, and this is one case where the tenant may want to try and negotiate. Well, if we install this, we may incur substantial expenses, and if we can remove it and make sure there's no damage to the walls or flooring or what have you, why shouldn't we take it back? The landlord will argue, well, it's our space, you installed it, although we gave you permission. If you removed it, it would cause too much damage, and you put it in, but now it's ours and we don't have to pay you for it. So that's usually the way it ends up. So a tenant has to be careful that if they do make an improvement to the space or install something, some piece of equipment, for example, they better be sure that it's sort of portable, whereas the landlord will likely argue, well, it is a permanent fixture, therefore it's part of the space, and you have no right to take it back.
Obviously, with these with these deals where you've got you want a long-term lease, right? And it kind of serves everybody to have a long-term lease, of course, until the moment that it doesn't. Article 31 talks about the option to extend. There's an option right, there's an option rent, there's comparing it to market rent in here. I assume most of this is fairly standard, but what are you seeing in here in terms of the ability to keep going with the lease? Is there anything, again, fairly one-sided, but is there anything that you would raise a red flag on?
Well, just the way the rent is structured for if there is a renewal or an extension. I mostly see a dollar figure with stepped-up rent as opposed to making it market rent, but either way, the landlord is probably going to get a lot more money if there is a renewal. You rarely will see the rent decrease. So if it is market rent, landlord pretty much knows that they will get an escalation on payments. But more often than not, you will see a dollar figure, and then the rent will increase per year by a percentage basis based on the previous year's rent. That kind of thing. This seems a little wordy and a little complicated, how the market rent is determined through an arbitrator and that kind of thing. But obviously, landlord in this instance probably has a lot more leverage than a typical landlord would have.
I'm thinking as we wrap up, back in the day, like I mentioned, when we had a conversation about leases, it was in the middle of COVID time, and I remember having a conversation about go push the buttons, right? Like go see what you can get away with, what you can actually extract from the landlord, because this is a time that, they need some things. They need some people to go fill some rooms. What's your sense of the market today? I mean, how are you feeling about the market? What power do tenants have to kind of push back on these standard terms and get what they want out of it?
Yeah, it's a great question. In pretty much every major city, I've done a lot of research on this. There's still low occupancy with most office buildings. In Atlanta, for example, it's more the higher end buildings that have more occupancy. It's the Class B or the Class C space, as they're often called, that are really hurting for new tenants. So obviously, if you are a tenant, you have a lot more negotiating room. You can not necessarily get free space, but maybe you can get free rent for first few months, maybe even a couple of years. If you sign a long-term lease, you can get other concessions, get the landlord to build out the space for you, that kind of thing, give you a build-out allowance. So it's really a tenant-friendly world these days, because with so many people working from home during COVID, that really hasn't changed. A lot of people still working remotely, and now you've got all these office buildings virtually empty, and even the landlords that have space that never closed down, they don't have people coming in the office every day. So there's still a lot of vacancies, and you see a lot of landlords these days that are looking to sublet space, within certain premises, especially in the office setting.
Well, that's super helpful, both for people who are drafting these kinds of documents and who are looking at maybe signing one of them. So I appreciate that perspective. Stuart, for people who want to learn more about you and your work, what's the best way to reach out to you?
Yes, please feel free to connect with me on LinkedIn. It's Stewart, S-T-E-W-A-R-T, Banner, B-A-N-N-E-R. Always happy to connect, and if you ever have any questions, I will answer those. I'm very prompt with responses, and you can always email me or even call me if you do have a specific question about commercial real estate and other areas. But I've been doing this for about 30 plus years and seen a lot of changes. I've never seen it where it's more a tenant-friendly environment. So if you are a tenant out there, you want to lease space, you can likely get a good deal.
Great. Well, we'll make sure that information is over on the website at lawinsider.com/resources. And if you want to be a guest on the Contract Teardown Show, just email me. I'm at community@lawinsider.com. We'd love to have you. Stuart, thank you again, and we'll see you all next time.
Thank you, Mike. My pleasure.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.